The first session is on your responsibilities under the Open Meetings Act and under the Access to Public Records Act. Those are two critical things. School committees frequently run afoul of the open meeting law. Sometimes they go into executive session for the wrong purpose or the wrong reason. And how you avoid that, and no one wants to be fined. I think the penalties are now $5,000 per person for violating. I mean, they can impose that. They don't necessarily have to. But we have Adam Roach, the Special Assistant Attorney General, who does professional development around the open meeting law and APRA. APRA is another factor that you have to be aware of. There will probably, again, be proposed major changes to both those statutes in this session of the General Assembly. It remains to be seen whether they're going to enact that, but Adam might be able to touch on those as well. And there's always a healthy portion of time for the Q&A. Adam, I'll turn it over to you. Take it away.
Thank you. Good morning, everyone. This is a relatively, when I do it in its full form, it's a relatively long presentation, but given the time constraints, I'm going to go through it fairly quickly, and hopefully I'll leave about 15 minutes or so for questions. So I know there's often a lot of questions with this one. So we'll start with the Access to Public Records Act. Now, I would say as individual members of a public body, you have a duty with respect to this. It's probably not as transparent to you or as palpable as like the Open Meetings Act, but nevertheless, you, as members of a public body, still play a role in the APRA, so we'll go through that first. So basically what it is, it's public transparency. All open meeting laws are established in the spirit of transparency. We do the work of the people, and they should be able to access our information with some important exemptions and exceptions, and we'll get to that. So pretty much, I mean, this is a pretty easy one. It's a little bit more difficult under the Open Meetings Act to determine whether a public body's subject to the Open Meetings Act, but if you're a public body in some form or another, your records are subject to the APRA. The federal equivalent is the FOIA, so they kind of go hand in glove. So for example, right, you couldn't file a public records request with the Crown Plaza. It's a private entity. But there are exceptions too. There are situations where a private entity will assume, this is very rare situations, but we have found where a private entity is taking on fully a government responsibility. So this is just a silly hypothetical. But imagine the Rhode Island government decided to say, the Crown Plaza Hotel will take on all the duties of the Rhode Island Department of Transportation. For the next 2 months, we won't have a Rhode Island Department of Transportation. The Crown Plaza will be our Rhode Island Department of Transportation. Well, in that situation, it's no longer a private entity, it's a public entity because it's assuming all the duties of a public entity and therefore would make it subject to the APRA. And the way in which these laws are written, it's very beautiful because it anticipates loopholes like that. So say I don't want I'm a public body, I don't want my records to be exposed to the public. I'll just say, I'll just have a private entity do our work, and then they're no longer subject to the APRA. Well, no, the law anticipates that and puts in findings like this and provisions in the statute to cure that. So every public body has to establish written procedures. They're usually, and we'll skip here, this is what they have. Who the public records officer is, how to make a request, where to make a request, and the request doesn't have to be on the form so long as it's readily identifiable as a public records request. So we have received and answered public records requests that were written on a Post-it note because they were readily identifiable as a public records request. Now, it's important to note that sometimes there are informal communications that are for members that are seeking records, but they're not clearly APRA requests, they're not clearly public records requests. That's oftentimes a situation where someone's not following the procedures of the public body, they're just kind of emailing a random person at the public body and saying, hey, I want these records. and they're not saying, hey, I want these records as an APRA request. And we found that you're not entering the realm of the APRA, you're just kind of informally seeking records. But as soon as it becomes identifiable as an APRA request, then the APRA as a law kicks in. So that's an important distinction. So these procedures, they need to be on the public body's website, and this is changing. With every passing year, more and more public bodies have websites, and we no longer have the days where you're a public body that doesn't have a website, but say that is the situation, you're a public body that doesn't have a website, it just needs to be readily available. So if you go to the office and say, hey, can I have your APRA procedures? Sure, I've got a stack of photocopies of them, so they're readily available to the public if they're not online. It's fine. And you also don't have to provide a reason for it. I get a lot of questions. I don't know why this person's asking for these records. Well, it doesn't really matter. They can ask for anything they want. They don't need to justify it, even though I have seen some bizarre public records requests in my career. Nevertheless, you don't need a reason for that. So another important note, and I get a lot of people because not only are we subject to the APRA, as a public body, the AG's office, we also referee, that's why we're here, we referee disputes about the APRA and the OMA. I get a lot of complaints that are just people who are asking questions of a public body. That's not a cognizable APRA request. So you can't just say, tell me what ask any kind of question. But if you're seeking a specific document, that's cognizable under the APRA. And you can't ask a public body to generate a document that it doesn't already maintain. However, if it's easy to generate that document, a few keystrokes, right? It takes a few keystrokes on the computer for me to generate an Excel list, even though we don't have one saved in a folder somewhere. Then that, under the APRA, you have a duty to produce. And our office's philosophy, and we hope the philosophy of most public bodies, is you want to be as transparent as possible. So even if you don't necessarily have an obligation under the APRA to answer questions, if you have a document that answers most of those questions, just provide that document. Or if it's not a huge undue burden to create the document that they're looking for, just create it in the spirit of transparency and produce it. That's always you always want to be as transparent as possible. You never want to look to deny records to the public. You want to produce as much to the public in the spirit of transparency. So when a public body receives a APRA request, there are X amount of ways they can go with it. They can extend the time period by 20 business days. But you can't just say, we're extending this by 20 business days. You have to give a reason why you're extending it. So the burden of the search, the number of other APRA requests we're working on at this time, the various reasons. But that needs to be you can't just say we're extending it as a boilerplate response. You can deny the request, and we'll get more into that, and then you can grant the request, which is just giving them the records. While calculating the 10 business days, it begins from the date of receipt. So data receipt is day 0, and then you count forward, 1, 2, 3, 4. State holidays do not count. Now, it's important to keep in mind, we're talking state holidays. So there are cognizable federal holidays that aren't also state holidays. The APRA is a state law, so we don't count those federal laws. We just count the state laws. The request needs to be within business hours. So if you get a night owl who sends a request at 11:30 at night, then in practice, really day 0 starts the next day. You received it the next business day. However, again, I'll oftentimes say, but the way we do it, the way the Attorney General does it, we always want to be as conservative as possible, as careful as possible. So oftentimes we'll just calculate it starting from 11 a.m. as day 0, 11 p.m. as day 0, because we just don't want any kind of excuse to say that we violated the APRA, so we try to be as careful as possible. But from a technical standpoint, it's the next business day if you receive it outside of hours. These are the reasons I talked about. Difficulty of searching, voluminous nature of the request. You just need to explain why you're extending the time to respond. So basically anything that the public body maintains is public record. So photos, documents, Excel files, anything like that. So you receive a public records request. You need to conduct a reasonable search. So again, I'll go with kind of silly hypotheticals, but if you receive an app request, the response shouldn't be like, oh, this isn't something I think we'd have, and then end it that way. What you need to do is like, we receive the same kind of app requests all the time at the Attorney General's office, so we have a pretty mechanized way to we know where, okay, this is a request for a criminal file. So we find out who the prosecutor is. We go to file control. We obtain the criminal record from file control. We go through the entire file. We talk to the prosecutor. We make sure that there weren't any files that he saved anywhere else. We speak to the paralegal. We make sure there aren't any files. So you kind of have to shake the coins out of just make sure you've gone to every single possible place and then you feel good that you've talked to everyone who could possibly have those records. And it's the same we get requests for consumer complaints. We're not going to ask the criminal division. We're going to go to the consumer division, ask the consumer chief. The consumer is going to say, oh, those, auto dealer cases, they are handled by this attorney. We go to that attorney. It's like kind of detective work until you get to the point that you're confident that we don't have the records, or we do and we provide them. So this is just kind of showing from the old NBC, The West Wing, all the different places where records could be: bookshelf, desk, etc. And all these people, you got to ask them and make sure you've asked them where the records are. So again, as I said, there's no requirement that you draft a summary explaining the documents or that you create a new document. You don't need to do any kind of reorganizing work. It's just the way the documents exist and provide them. But again, as I said, if it just takes a few keystrokes, then you need to produce it. So a minor distinction there, but important. The APRA, and again, I'll foot stomp on this. The APRA is a floor and not a ceiling. So what I'm talking about is the bare minimum of what's required under the APRA. We as an office, and we encourage the public to always go above and beyond. So you want to be as transparent as possible, understanding the constraints of public bodies. We don't have all the time in the world to always just be responding to app requests, but there's nothing wrong with transparency. We want to be as transparent as possible. So the APRA is a floor, it's not a ceiling. You have to state that you have to make sure that any reasonably segregable portion of a record shall be available. So what does that mean? Say you have some kind of a document that contains non-public information, home addresses, social security numbers, check routing numbers, things, all that are non-public. Well, nevertheless, even though that information is there, you still have a treasure trove of information within that document that's public. So you have to provide, you redact out those portions that are non-public and then provide all the rest that's public. And then I'm skipping ahead a little bit, but if you're denying a request and saying we are not giving you this record, you have to state in the response that no reasonably segregable portion is producible. So you have to basically, that's lawyer speak for saying we can't redact this. There's no way to redact it. If we redacted everything in this non-public document, all you'd be getting is a blank piece of paper. So there's no point in producing that to you. But you need to say that in your response when you're denying something. The default position is it's a public record. But we all know from common sense, there are a lot of documents that just aren't public. So then that's when the exemptions come in. So this is when you're responding to an APA request, you deny the request, and you have to cite the exemption. You have to say what about that document renders it non-public. And that's for the stuff you're redacting too, not just if you're withholding the entire document. So for example, right, if discovery laws, like when you're in a lawsuit and you're exchanging documents, that's a lot more permissive than the Public Records Act, because you're giving the opposing counsel a lot of documents that the public wouldn't have access to. If you can't give it to opposing counsel in discovery, there's no way you're getting it under the APRA, because the APRA is more restrictive than discovery. So that's basically what that's saying. Drafts, notes, impressions. So if I'm writing I draft findings. When there's a complaint about the APRA, there's a complaint about the OMA, it comes to me, I draft a finding. My folders have a ton of drafts in there. for a number of reasons. One, I drafted it one way. I thought it was going one way. My chief of my unit said, well, I don't really think it's going that way. I think it's actually this way. Or the conclusion's correct, but we need to kind of tweak how we got there. So say there's an APRA request for my draft, right? Well, we don't want to produce those records, and here's why. If I produce a draft finding that it contains a conclusion that we decided is not lawful, is not proper, then that causes a lot of confusion because you have a document floating around out there that's seemingly an AG opinion that is not an accurate opinion. So there's a lot of reasons for exemption K, but that's an important reason, is we don't want to create confusion by producing a document that's not accurate. So that's exemption K for one reason. There's many other reasons. So this is another one. If the document is non-public based on federal law, right? Health records, HIPAA, right? HIPAA is a federal law. Health records are non-public. So when denying that request, if someone requested, if the AG had my health records, requested my health records at the AG's office, we would deny under exemption S because it's something that a federal law says is non-public. So not only would we cite to HIPAA and say, here's a federal law that says it's non-public, we also have a state equivalent that says it's non-public under the APRA. We also have a state law that says that medical records are non-public, and you just cite to all these things when you're denying the request. Exemption Z's specific to public school employees, individually identifiable evaluations of public school employees. I can tell you that I've never done a finding on this exemption, so I don't think it's something that's litigated very often, and I don't even recall ever reading a state court case, although they might be out there, or a finding from our office regarding this exemption. So I would, if you are heavily involved in the APRA, I would go to our website and just check out the APRA and check the definitions section, because the definitions section lists all these exemptions. Some are used a lot more frequently than others, but as you can see, we're up to Z here, so there's a lot of them. This is an important one, clearly unwarranted invasion of personal privacy. So this is like what kind of goes hand in hand with this one. So there's a lot of information. You're doing the public's business, so there's a lot of information that's just should be available is default public, right? How much I make as a special assistant attorney general, where my work office is, all my benefits that I get, because we're playing with state money. I'm not employed by the Crown Plaza, I'm employed by the state of Rhode Island. My business phone number, all these things. But then if you get into personally identifiable information, home address, phone number, email, then there has to be, we as an office and the individuals responding to an APRA request beforehand, they conduct a balancing test. So they want to see, okay, why is there a public interest in this? What is so important about this information that producing it is beneficial to the public? And then you say, what's at stake here with respect to producing this information that's non-public? And we have a lot of cases that we can read and consider, and then we conduct an analysis ourselves, and we determine whether it's really a balancing. It's 51%. Is there a public benefit to that information being rendered public? So that's where AIB or AIA comes in. But oftentimes, I'd say, when you get to that point, there are often other exemptions that are at play. So the records may be rendered non-public for a different reason. So it's not often that it's just kind of subject to the privacy balancing test. But we did have like one finding, for example, where there was like tax information that someone was seeking, and they didn't even provide a public interest for why they wanted that. So that's an easy one. You're not helping us engage in the privacy balancing test. And then there was another one where someone kind of said, well, I don't know yet, but I think if I get this information, it may, reveal that the laws aren't being enforced. Well, that's a little speculative. And when you're dealing with personal information, you need something a little bit more tangible to produce that information, as opposed to kind of a speculative, I think if maybe I get this information, I'll learn. Well, that's not very concrete. So private interests, if it's a private citizen, that's at the highest, the apex. So I'm not a private citizen, I'm a public citizen in my capacity as a Special Assistant Attorney General, but we interact a lot with like law enforcement agencies, so they had police reports, right? A private incident involving someone at their home or something. So that's, they're a private person. So when we're conducting that balancing test, we're like, okay, this is where the privacy part's kind of at its apex, because this isn't someone who is engaging in public business. It's a private person, so you need to take that into account. So any costs are borne by the person making the request. So if they're requesting like hard copies that are photocopied, it's 15 cents per copy. And then a $15 charge for search and retrieval after the requester gets the first hour free. So when someone will ask like for a huge request, right? We want all of my emails from when I started at the AG's office in 2017 to the present, right? Well, we can produce that. It'll just take hours and hours and hours and hours. And I'm an attorney. There's a lot of non-public information. It would take hours and hours and hours to review and redact. So nevertheless, we'll come up with an estimate. It'll, in that case, my hypothetical will be astronomical. But for each hour that we determine it would take, it's $15 per hour for us to conduct that process. And oftentimes, too, if someone is making that request and we're like, this will take a really long time, what we do is we suggest that they narrow it because, again, like we're trying to help them access the information. You can always waive fees too. We try to as much as we can, and we suggest you do as well. As the costs of redaction should be borne. So again, if you have a stack of documents, most of it's public, there needs to be a lot of redaction involved. That's $15 per hour. That's borne by the person making the request. They're the ones who need to pay for that. You might have heard of or know about people who like just make public records requests all the time. They just like submit request after request after request. So it's important to note that that first hour that they get is for free. Then that doesn't carry over the next request. So the next request isn't free. So you can calculate prepayment. You get one request, exhausted your first free hour, then you realize the next request would take 2 hours, then you can bill them for two hours, not for $15 1 hour, because they're not getting their free hour anymore. They exhausted it, which is helpful. I think the APRA has become more popular. You're seeing a lot more people who make like tons of requests all the time. And when look, the complaints come to us. So I see like the cities and towns or agencies that are having trouble with it. And I think the biggest, where people get into trouble is they just try to like fully satisfy all APRA requests, not taking into account what they have at their disposal, which are extensions, prepayment, and this provision here to take away that first free hour for the next subsequent request. So you want to balance it. Obviously, you want to be transparent, as much information as possible. You can't cripple your agency by just responding to app requests all the time, and then you can't subject yourself to findings from our office and potential lawsuits by not following the APRA because of your agency being overwhelmed. So if you're waiting for that payment, it's not the clock stops, it tolls. So if you assess a prepayment fee, $45, 3 hours, and they haven't paid you yet, you don't have an obligation to fulfill the request because you're awaiting payment first. Members of the public, they can ask whatever form they want it in. So if you have it in Word and they want it in PDF, the statute says give it to them in PDF. Unless it's like unduly burdensome, some weird software they want or something, you're like, hey, we don't have that, or we'd have to install something in the state computers. But otherwise, if you can, just give it in the form that they want it. So denial is, we use the term denial in the APRA, but denial can mean like just not responding is a denial. Withholding records pursuant to the exemptions, it's a denial. And then stating that you don't have records, it's also considered a denial. A denial sounds like a kind of like a mean word for this, but that's just the statute. But it encompasses kind of every manner in which a member of the public won't get the records they're looking for. So these denials, they have to be in writing. So you can't get an APRA request, call the person up and say, hey, sorry, we just don't have them. You have to put it in writing. You have to state the specific reasons. We don't have it. We have them, but they're exempt. And then you must always indicate the procedure for appeal, no matter what the response is. So what we do is in each APRA request we have, no matter what the result of that APRA request is, we always include this language. We have it saved and we include it in all our responses because it's required by statute. Basically says, you don't like our response, you can appeal it to the Chief Administrative Officer. In our case, this is going to the Attorney General, Peter Nerona. He'll review that himself. We don't get a lot. We get a couple each year. But it's at the public's disposal to do that as well. So you just save that appeal language. And they have my boss in this case, Peter Nerona. Did I say Kilmartin? I meant Nerona. He has 10 business days, just like an APRA request to get to it. Communicate with the requester. I know, like, if some of you do public records requests, it can get vexing sometimes, the same characters, the same kind of sometimes obnoxious requests, but really the best way to handle it I've found is communication. And as soon as, like, if you get a voluminous request, you just pick up the phone and say, hey, or email. Email's better to have it in writing and just say, hey, look, we could try to get this to you, but it'll take a long time. It's going to cost you a lot of money. How about this? How about we try to provide you with this? And then try to get to some kind of a agreement. Communication always, 9 times out of 10, will resolve issues before they get to our office, which we hope for the result to be. We'll fly right into Open Meetings Act. I want to leave some time. So, meetings, if you're subject to the Open Meetings Act as a public entity, your meetings are open to the public with some, like the APRA, it's very much like the APRA, with some exceptions, and that's what you would call executive session, which per the statute is sort of used sparingly. And like the APRA, where you state the reason for denying records, similarly in the OMA, you state the reason for going into executive session. We'll get into that. So it requires open meetings, limited circumstances, executive session, or closed meetings, and then notice annual, which really it's not much of an issue. I haven't encountered many issues with annual notice. That's just listing the number of meetings you'll have on an annual basis. Supplemental notice, that's another word for agenda. A lot of complaints about that, so we'll get into that. Meeting minutes, really not a heavy lift, but nevertheless tends to be a lot of complaints to our office about meeting minutes. Much like the APRA, again, the APRA and the OMA, even though you're talking about something tangible in a meeting, they're kind of like mirror each other. The OMA is a floor and not a ceiling. So again, you want to try to be as transparent as possible. Skipping ahead a bit, surprisingly to a lot of people, public comment is not required under the OMA. There's no requirement under the OMA that you have public comment. Nevertheless, in the interest of transparency, why not allow for public comment? You don't want to have 5 and 6 hour meetings if you're getting to that point, but nevertheless, the OMA is a floor, not a ceiling. So even though it's not required to have public comment, you may want to consider it in the interest of transparency. So this is a really, I think people get all kind of tied up in knots about the OMA, but if you kind of break it down to very simple, this simple model here, you need all 3 of these things to happen for the OMA, for the law to even be triggered. So if one of these things is missing, the law isn't in place. So you can't violate the law if one of these 3 things is missing. So if you don't have a quorum of members, the OMA is not in place. If you're not a public body, the OMA is not in place. If you're not having a meeting, the OMA is not in place. We'll get into that a little bit more. And that's easy for me because sometimes I receive a lot of calls from members of the public. They'll be like, I think that this entity, had a closed meeting. I'm like, well, how many members of the, I can quickly determine it was less than a quorum. I'm like, well, it was less than a quorum. It wasn't a meeting. The OMA wasn't in place. So this is a little bit trickier. What is a public body? A lot of people, like when they call, I can give them I can point to something in the statute and say exactly, this is what the statute says. Whether an entity is subject to the OMA is a trickier question. You kind of take a number of factors and weigh them all and look at them all, and based on all of those factors, make a determination, and we do all the time, as to whether an entity is subject to the OMA. I would say, obviously, when in doubt, just comply with the OMA. I hope that through this presentation, it'll become apparent that the requirements of the OMA are pretty, aren't that burdensome, such that it's easy to comply with. So if you're in that area of doubt where I don't know if we're subject to the OMA, just comply with the OMA, because then you won't violate the OMA. And the structure of the OMA promotes transparency, so even if technically you're not subject to the OMA, you're practicing transparency by complying with the OMA. That's basically what I just said. So I would say some factors that I look at whether an entity is subject to the OMA. So if someone calls me and says, I'm not sure if we're subject to the OMA, and they explain to me that they don't have regular meetings, they don't have regular membership, there's no charter that created them, there's no statute that created them, there's no consent order that created them. These are all factors that point to me. I'm like, oh, you just kind of like randomly get together sometimes, that's not subject to the OMA. All those other factors, though, regular meetings, regular membership, created by a charter, created by statute. What makes it really easy is some of these public bodies, it says specifically in the Rhode Island general laws, this entity is subject to the OMA, which makes it a lot easier for the AG's office to make that determination. So quorum, just a simple majority of the public body. So 6-member public body, 4 of you are meeting, you've got a quorum, the OMA is in place. It's important to, I'm sure, as prospective members or newly elected members of public body, you may have heard this term, rolling quorum. So how the law is beautiful is it anticipates ways that the law can be circumvented and drafts something to nip that in the bud. So like a rolling quorum, a walking quorum is like, well, we want to share information in advance of the meeting, but we don't want to create a quorum and violate the OMA. So less than a quorum is going to meet here. They're going to tell me what they talked about. I'm going to meet another less than a quorum over here and communicate exactly what they said, and I'm going to be the conduit. Then you create a rolling quorum, which is a way to get around the OMA, which violates the OMA. And that can be done electronically too. We'll get to that. So they can be created by a third person. So say I just decided to, insert myself into the activities of a public body, and I decided to be the conduit between these two factions that are kind of less than the quorum to circumvent the OMA. That third person, oftentimes it's been created actually, believe it or not, by like a town executive. So if you have a mayor or something, and the mayor talked with less than a quorum of a public body and then communicated to another, sometimes this is unintentional too, to be honest with you, and just communicated exactly what he or she communicated with the other less than a quorum, that conduit by the executive created that rolling quorum. This is a big one, and we have findings that you can access about this. So a Facebook post from a member of a public body about a subject that public body is within their bailiwick, within their jurisdiction, and they're just kind of sounding off on an issue. Then you get a comment from another member of that public body. Then you get another comment from that. And once you get enough comments that you get a quorum, then all the factors of the OMA are in play. You've got a public body. They're discussing substantive business. They're not discussing the Patriots or the Red Sox. They're discussing their business. You've got a quorum, and we found that violates the OMA. If you have a quorum and you're a public body, but you're just discussing, Coach Vrabel and how the Patriots will do next year, and you limit your conversation just to that, you do not talk about anything except the New England Patriots, then that third leg of the stool is missing. The meeting portion of the meeting is missing, so the OMA isn't in play, and there wouldn't be a violation of the OMA. I would warn against stuff like that. I get a lot of questions about, well, just social gatherings of the public body. A number of reasons. One, you're all came together because you're like-minded people working on, the public entity's cause, right? I don't think you can stay together for that long without discussing some kind of pressing issue that public body is working on. I think it's very difficult. So even if unintentionally you start to slide that conversation into something that your public body does, then you've got an OMA violation. But thinking perhaps you're like super disciplined and you really like from the time you got there to the time you left, you talked about the Patriots and Coach Vrabel. Nevertheless, say you're doing it like a coffee shop, right? And a member of the public strolls in. They say, "Oh, I saw the school committee, and there's a quorum of them, and they were all talking about something." And then the whispering starts, and then it becomes the optics of it are bad. It looks like you're meeting non-publicly, and then I maybe get a complaint, and I have to investigate it, and it's less work for me if you don't have those social gatherings. Not that that's why my biggest consideration transparency is, but. So this is, during COVID, we had, all right, so the law was written a long time ago. The law did not anticipate the ability we have to meet virtually. So the law, as written, requires members of a public body to be in a physical brick and mortar location during that meeting. We had the COVID-19, so we had virtual meetings because of the public health crisis. That's not part of the statute. That was due to an executive order that allowed for that to happen because of that. So the governor's executive order. That executive order expired. So we are back to the requirements of the OMA as written. And the requirements of the OMA as written are that the members of the public body need to meet in person. You can schedule meetings. There's some exceptions here. A disability, that we don't make that determination in our office, but you need to get a waiver. And then public active duty, armed services. There are limited exceptions that allow for this remote participation, but really, most of the time, it's everyone in the public body in the building together. That's been talked about. There's mention of perhaps amendments to the OMA. That's been discussed as an amendment to the OMA. That's what I just talked about. So executive session, right? So the default position is you have your meetings open, and then executive session is a closed meeting, but you need to keep that as limited as possible. It's like the APRA. You want to redact as little as possible, just that non-public stuff that's not public. Same thing for executive session. You just want to discuss the non-public stuff. You can't discuss anything else. And then in your agenda, in your supplemental notice, you include the reason why you're going into executive session as a part of the agenda. That's a requirement of the OMA. So you'll say, the agenda will say executive session. It'll say the statute, the provision of the statute that allows for that executive session, and then a very brief discussion of why you're convening into executive session. I've had numerous conversations with your solicitors and counsel for your public bodies. This is tricky for some. The way I explain it is like, just explain why you're meeting and get so close to that point where you're going to disclose the non-public information, but you don't. You explain it as closely as you can without revealing non-public information. I'll show some examples that have been kosher. We'll get to them a little bit later, but this is a big one, right? So litigation. You don't want to discuss your litigation strategy in open meeting because defense counsel or plaintiff's counsel can click on the Zoom link and all of a sudden they have all your litigation strategy, right? Same for collective bargaining. If the union just kind of attends your meeting, then they know where your position is on collective bargaining. So a lot of this is just common sense. These are things you wouldn't discuss publicly. Same thing if you're discussing RFPs or bids for a contract. If and weighing certain vendors, you wouldn't want to give one of those vendors a commercial advantage by having that information. Civil or criminal misconduct, that's a big one. So say, an employee, if you're a public body that has X amount of employees, you think someone might be doing something improper with funds or something. But again, just like I don't want my drafts of findings to be public, if there's an allegation and it turns out to be unsubstantiated, I don't want that information to be public because that's unfair. Because if the public body convenes an executive session and hashes it out and realizes it was all a big misunderstanding, now that individual has been besmirched and there's been a public meeting discussing whether or not they're doing something improper with funds, just as a hypothetical. So it's the same reason. You don't want that. That's not something that should be discussed publicly because there hasn't been a determination on it yet. Student disciplinary hearing, so that's something that might be specific to school committees. Again, not something that I've encountered much findings-wise or complaint-wise, but just that's the provision there, 5A8, and that can happen in an executive session. So public notice. Annual notice, as I said, maybe one complaint I remember in my entire career. That's just listing your meetings for the year. And subject to change because we get snowstorms, we get whatever. People have to reschedule. Supplemental notice. This is big. This is the agenda. It must be posted at a minimum 48 hours in advance, excluding weekends and state holidays. So, and you always want to give yourself as much wiggle room as you can, but I understand because members of the public body, they're trying to get stuff on the agenda, they're trying to make edits, and a lot of town clerks and whatnot are right up at that 48-hour time hack there. But that's key, and I get a lot of calls trying to say if any public bodies can be excused from this posting requirement. No, it's pretty firm. It's 48 hours, and really, it's unfortunate because it may be inconvenient to people, but if it's better to just kind of cancel the meeting rather than violate the OMA if you're not able to get the agenda up. The principal office of the public body and one other prominent place within the government unit. There's so many different agencies that I couldn't tell you, Rhode Island Department, I can't even come up with a hypothetical because we've got massive agencies and we've got really small agencies. But the big one's the Secretary of State's office. We get some complaints about the physical posting occasionally, but we get most complaints about posting electronically. We'll skip annual. Supplemental, date and time, location of the meeting, date posted. The big one within this subtopic is statements specifying the business to be discussed. We get a lot of complaints about that. I'll explain why. So you can't have a broad agenda item. You can't have, we found agenda topics called good and welfare. That was one once. We found that to violate the OMA. I guess the way to think of it is this way, right? If you're a member of the public and some kind of school action or some kind of a zoning action or some kind of a town action will impact your property, impact your child and their classes or the classes they take, their facilities or whatnot. If that's discussed by the public body under the phrase good and welfare, you would have no notice that something that would directly and personally impact you would be discussed by a public body because it's shrouded by a vague and broad term. However, if you comply with the OMA and say proposal to build a new cafeteria at X school, right? Then I know exactly that topic that may impact my child who's a student at this school is going to be discussed by this public body. And that's really what it is. That's why there's this requirement within the OMA. It's to properly alert people of what the public body is going to be discussing at the meeting. So these are from our findings. These are things we found violated the OMA. Because how will I know what's old business? How do I know that? What's new business? I don't know. There needs to be more specificity there. Executive session we talked about. So you just have to identify exactly what's going to be discussed in executive session and the statute and reference the statute. These are what we found to be permissible. town manager performance review, police union negotiation, potential litigation regarding a land dispute. So then you're not getting into what is this land dispute, who are the parties. You're not getting into that, but nevertheless, you understand why the rationale for the public body going into executive session and the statute that permits that. So you can amend an agenda at a meeting, but it's under such limited circumstances, and it's really not impactful that it doesn't really happen that often. So for school committees, this is the one way that the agenda can be amended. Submitted in writing by a member of the public during the comment session for informational purposes only. So there's so much hedging language here that it's, again, I don't mean to be, to not have much practical examples for things that directly impact school committees, but there's such limited impact for amending the agenda here that it's not very controversial because it's just for informational purposes. It's not really having much of an impact, and it's during public comment, which is not required under the OMA, but that's one way to amend the agenda. You can have emergency meetings. It has to be like a real emergency, and it has to be convened just to address that topic. So again, drafters of these laws looking for loopholes, thinking of a public body that kind of wants to not really comply with the OMA and say, we'll call it an emergency meeting and then like meet and discuss other topics. No, it has to be limited to the topic that's the emergency. And then you kind of have to engage in some remedies to cure the fact that all the other requirements of the OMA weren't complied for given an emergency. For example, you have to state exactly why this issue had to be addressed in less than 48 hours. And then post the notice and agenda as soon as you can thereafter with the Secretary of State. So you're just kind of like, you're curing the way the OMA was impacted due to the emergent nature of the meeting. Public comment, as I said, not required. There may be, this is like a caveat to everything I say. There may be another statute out there that's applicable to your specific public body or a certain set of circumstances where public participation is required. I don't have any examples off the top of my head. And it's, so it may be required by an outside statute, but I'm telling you the OMA, which is the extent of my jurisdiction, is not required under the OMA. This is another thing. So as I said, the notice requirement, right? So it has to be very clear from the agenda exactly what the public body is discussing. Where we found violations before is that I'm a member of the public body. I really wanted to discuss this issue, but I hashed it out with the other members of the committee and they wouldn't they wouldn't put it on the agenda. Oh, but public comment's coming up. So, someone's going to ask me a question and I will answer their question and I will segue right into the topic that I wanted to talk about, which wasn't on the agenda. That's an OMA violation. You can't do that. You can only address the premise of the question that was raised by the member of the public body. And these are all, like a lot of these things, I make up a lot of silly hypotheticals, but some of these things are right out of findings. And that issue with using public comment to segue into something else they wanted to talk about is from findings that we found violated the OMA. Meeting minutes, the requirements are very Spartan. So here's all: date, time, place of meeting, who is absent, who is present, record of votes taken, and other information that say, I'm a member of the public body, I want the minutes to reflect, then they can be included in the minutes. So really, it's just the key number here with meeting minutes is 35 days. So they need to be either available to the public in draft form or posted on the Secretary of State's office within 35 days. The exception to that is an advisory public body. What an advisory public body is it's an entity that is subject to a lot of the provisions of the OMA, but they have no enforcement mechanism, so they can't enforce anything. They can just provide recommendations, and the enforcement comes from a larger entity or a more powerful entity. So they just meet and convene and say, here are recommendations for, the public parks for next year, but they can't do anything themselves. Then they're not required. But again, in the interest of transparency, they'll often just post minutes, because it's good practice. persons with disabilities. So, that goes without saying. You can't hold your meeting in a place that's, accessible by like a rope ladder only. Again, a silly hypothetical, but to illustrate it. And then, good, I got like 15 minutes for questions. So go to our website, go to the open meetings, open government unit section, and you can get all our resources. And I'm happy to take questions.
So at what point does a draft cease to be a draft and advertise? And then my other question was about subcommittees and the OMA.
Yep.
Like, is the forum the same with the subcommittee body, or is it school committee in its entirety?
Starting with drafts, I think it's like a facts and circumstances type deal. I would say that a finding that I do is not, it's in draft form until it's, published through our public portal, which is clerk-based and is deemed an official finding. Any kind of like draft of something that is in litigation that hasn't been filed with a court yet. Once it's filed with a court, it's no longer a draft, or those other versions, but you can have prior versions. And if there's really any question, it's usually readily identifiable based on the records that like something was published or something was filed with the court, and you're like, okay, this is clearly not a draft anymore. But if there's any doubt, we usually just rely on sworn statements, affidavits that saying, this document's a draft, I never meant to publish it, it hasn't been published. So affidavits or sworn statements kind of fill in the blank there. So I need to be very careful with, because I've caused some confusion, I think, in the past with my remarks about subcommittees. So I'll put it in very kind of clear terms, I hope. So I don't want to use the formal term subcommittee. So oftentimes a public body needs to take action and gather information, but they don't want to violate the OMA. So they send less than a quorum to gather information at maybe another public body's meeting or something and bring it back to the public body and report that information to the public body. They may use the phrase subcommittee to reflect those two people or three people, whatever's less than a quorum, right? But again, it's not, those folks are not, even though you may call them a subcommittee, they don't have all the indicia of a public body. They're not meeting regularly. They don't have a set membership. They weren't created by charter. They weren't created by statute. So they're not really a public body. And then you've got like more formal, like this is the subcommittee, and it's like, and all those factors are in place that would render it a public body. So they have a fixed membership. There's a distinct membership from the larger public body that forms that subcommittee. They meet very regularly. There's some kind of a document that determines that a subcommittee shall be created, and then it has kind of, it more closely resembles a public body, and it has the term subcommittee. I would say when in doubt, especially with school committees, defer to legal counsel for the school committee. And then step two, when in doubt, if you think it's close, just conform with the mandates of the OMA. And then like, just think of, and then step three, think of the factors, right? All the things I talked about. And if it starts to closely resemble something like a school committee that's clearly subject to the OMA, then I would begin following the mandates of the OMA. Sure. Yeah, if there's like a policy within the public body that we are not going to comment on things, that's, my lane is the OMA, right? So that would not violate the OMA because...
It keeps you from violating the OMA too, right?
I would, any measures that are kind of ensure that people don't speak on something that's not properly noticed, obviously it would be something that would keep a public body within the lane of the OMA. But the more important point here, I think, is that public bodies can kind of create whatever rules they want to follow between themselves, and if it's not within the scope of the OMA and it doesn't violate the OMA, I can't really opine on it because I don't have jurisdiction to say you as a public body should or shouldn't do this.
Everybody's hands went up at once, so it was a tie.
So Adam, you said at the beginning
guess
of the
not.
session, and I quote, as a public body, we have a responsibility to be as transparent as possible. But on slide 65, page 22, you talk about Rhode Island general law, sessions or work sessions pertaining to collective bargaining or litigation. Is it an inherent contradiction that collective bargaining discussions are held in executive session? Is there a law that states in Rhode Island that collective bargaining discussions must be held in executive session? Why aren't those things held in open session?
So I can't speak to any outside statutes that would require that to be public. I can just speak to the OMA, which permits that discussion to be held during closed session. And I don't think the two are contradictory because the premise is always that the OMA is a floor, not a ceiling. So if you can discuss something openly, we certainly encourage that. And that closed session should be used sparingly as much as possible. So if you can have a closed session, which really doesn't take a lot of time, I think that's preferable. And then, I think like for collective bargaining, I'm not a collective bargaining expert. I just don't think, you don't want to say something publicly that would be unfair because it would give one party like a commercial advantage or a bargaining advantage or something. So that's really kind of what the theory behind that is. And yeah, it's really just kind of like, it really, you want to kind of limit the executive session as much as you can, really. That's how you kind of marry those two concepts, is just to limit the executive session as much as possible.
Okay, thank you.
Sure.
Is it true that if you're making like Facebook posts as a member of a public body, you can either allow all comments or no comments? Is that the rule?
So
You can't limit them.
I can speak to our findings, right? Which is that you shouldn't be conducting public business. Like the issue with that Facebook finding was that you had a quorum of a public body discussing public business. And even though Facebook is seemingly public, it wasn't properly announced. There wasn't an agenda. It didn't meet all the other mandates of the OMA. So
It was like informational posts, not necessarily conducting business.
well, then if it's informational, just advise the other members of the public body, don't comment on this. Keep
No, I
it-
meant for like the everyone else on Facebook. Like, can you either have to allow all comments from the public or no comments? You can't limit?
It doesn't. That's not really. That doesn't. That doesn't impact the OMA
Okay.
because you're not having the three-legged stool, right? So you're not having a quorum. You're not. So long as you're not having a quorum, the OMA is not impacted, so it wouldn't violate the OMA.
Okay.
Hi, I have two questions.
Yeah.
One, executive session minutes, whether they are sealed or unsealed, are they subject to an APRA request?
No.
So they can't be turned over to someone who asks?
If they're
for-
properly sealed. If they're sealed executive session minutes, they can't be turned over, but what we promote is to unseal them as soon as you can, and then thereby subject them to the APRA. You don't want to, we would advise against kind of like sealing executive session minutes in perpetuity. As soon as they're the reason for, so example, right? You sealed executive session minutes because you're discussing litigation strategy. The case is settled, the case is over, unseal the minutes, make them subject to an APRA request.
Is that a school committee vote to unseal the minutes?
I think it's an internal mechanism. It's outside the scope of the OMA. Yeah.
All right, and then my second question is, if an APRA request comes in, it's not the school committee member that's going to fulfill that. I assume it would be the superintendent and the staff of the school department. So is it best that the school committee just has a policy to ensure that the procedures to fulfill that request are maintained and available to the public? Is that kind of what we're getting at?
Yeah, I'd imagine if you're coming to a public body, like they already have these mechanisms in place. And again, I don't know, I've never been an elected official or served in a school committee or anything, but like, so I'm sure you engage with members of the public a lot, and that may involve requests for documents and requests for information, just being like a member of the public body. But I would, as soon as like the magic words APRA are used, or as soon as you get the inkling that like this is no longer just regular communication with a constituent, this has now become an APRA, then at that point I would determine what your APRA, who your APRA public records officer is for your public body, and send it off to them and be like, this looks like this is an APRA request now, and then they'll take it from there. They'll run with it. And there are exemptions in the APRA for investigatory records. Usually for law enforcement, I think there are some, if you're talking about like maybe a civil investigation of some kind, or private investigator, there are provisions within the APRA that would render those records non-public. But like I was just explaining with like sealed executive session minutes, everything always wants to be conducted in the interest of the most transparency possible. So to the extent that at some point that investigation concludes, and the reason for the secrecy is no longer needed, the reason for that investigation being, you know, say, God forbid, that investigation concluded like in a criminal conviction of some kind, right? And at that point, it's no longer investigatory in nature because we have a convicted, it's concluded. At that point, those records would no longer really contain that investigatory nature such that it'd be non-public. However, and I'm going into a rabbit hole here, there are also provisions for investigatory methods. So if I'm a law enforcement official, I use this special like investigatory, I use this technology, and I don't want it in the public because like if the public knew of the technology I used, then they could, you know, they could circumvent our law enforcement actions. So there's other provisions that protect information like that would, you know, that render it non-public.
Well, one of the, in conjunction with demanded that information. We tried to protect, we tried not to give it to them, and we lost. But it seems to me it ought to be protected by Apple.
Yeah, I mean, it's a facts and circumstances test. So every situation is unique and different. So I'm trying to like speak broadly to something that is really like, you can make a better determination based on all the facts and circumstances. But one thing to note is that a thing we always keep in mind with the APRA is that labels are not dispositive. So just because you can take a document and paste confidential on it, if you actually examine that document and read its contents, you're like, this isn't really confidential though. So labels are not dispositive. And I would say in the same spirit of that, communication saying, hey, what we're saying right now is confidential. So as myself as like an individual who's subject to the APRA and as a public official, I just kind of, besides things that I know are clearly non-public, my drafts, for example, I always operate in the spirit that at some point those emails will be public, my drafts will be public. We always kind of want to, I know that's not a satisfying answer, but you always kind of want to operate thinking that things will be disclosed eventually at some point.
Right here. Adam. So I spent the majority of my career in Rhode Island, in Connecticut. I spent 10 years in voice different Connecticut than it is in Rhode Island. So in Connecticut, for example, we can request that a teacher's file. We cannot include an evaluation, but we can include anything, a discipline record that was kept on them. What's the situation in Rhode Island in terms of either a teacher or administrator? Can you request their personnel file?
So I can analogize to, because for a long time I was the public records officer for the Attorney General's office. Luckily, I've gotten a sped up paralegal who can do most of that now. But we get requests for HR files. So we go to the HR department and say, the HR file for Adam Roach. And, you know, HR's kind of gut instinct is like, it's an HR file, you can't have that. But that's not the analysis. The analysis is to go through the entire file, document by document, and redact where you can, and produce in full where you can, and withhold in full where you have to. An example of that is, because I've gone through a lot of HR files, and you'll get W-2s. Now, W-2s by state law are non-public. You can't redact any portion of that. There's, by law and by the APRA, that's non-public. So you take that out, move it to the side. Like, okay, I've got some kind of a, like a hiring form that an employee got when they were hired. It contains a lot of personal information. However, then it describes in like 2 paragraphs exactly what their job duties will be. That's all public. So you take that document, redact out the, so it's really, what I'm getting at is that you take the entire file and you analyze it by document review. And that's how you do it. Sure.
We probably have time for maybe 1 or 2 more questions before we do the break. But just importantly, when we do the break, if you're looking for the restrooms, you go out the back just beyond where the buffet tables are. Those 2 doors, take a right and your first left, and you should be there.
We do allow public comment at our school committee meetings. If someone put in an APRA request, I'm sorry, not an APRA request, they want to be put on the agenda, and they were denied for whatever reason, and they come to the public comment section and start commenting about what they wanted to discuss, and we shut it down, is that a violation of their rights in any way? Or if they start discussing something other than what's on the agenda and we stop them, is that a violation of their rights in any way?
I can't speak to any like constitutional issues. I would say, you know, First Amendment, right? But I can just speak to the OMA. So I think you're kind of conflating two parts of the OMA. There's the supplemental notice requirement, which requires the agenda to set out exactly what the public body is going to discuss, and then there's public comment. There's no way of knowing what the public will discuss at public comment, so it's not subject to the same requirements as the notice requirement, because who knows what the public is going to talk about. So where you get into OMA violations is when someone who is not a member of the public, when someone who is a member of the public body starts discussing something that was not properly noticed during the public comment section, which was not the subject, the premise of what the member of the public was asking about. So say you're the member of the public body, I'm the member of the public. You want to talk about construction of the school cafeteria. My question is about a park that's nearby. You answer my question about the park, but then start discussing the school cafeteria. You can't do that. That is violative of the OMA. I, as a member of the public, I can talk about whatever I want. I'm not part of the public body during public comment. It's when a member of the public body starts talking about something else that wasn't on the agenda, that's where you get into an OMA violation. Sure.
Wait, one before you go. Quick follow-up on the discipline one. Hey, Aaron, Earl from North Kingstown. For the HR records, I understand what you were saying, but what about if in that file it's a disciplinary record? Is that subject to the public or not? Like, it feels like it shouldn't be, but that's what I was curious about.
I'd really have to have the document in front of me and understand the full context of it and the backstory and the conclusion of it to really make a determination. Again, I would say that, like, without having all that information, right, if that investigation, that discipline in some manner became public, right, there's really no reason at that point, because it's widely known. If it was, it's the same thing as like what I was talking about for executive session. If it's an allegation of some kind, and it was unfounded, and it was just an allegation, it was investigated, the individual was cleared, that would be unfair to them, I think, to produce that, because then you're creating a lot of kind of gossip or discussion of something that was never substantiated. But really, like, it's really a facts and circumstances. You have to look at the context of whatever that situation was and see whether it would damage that person's privacy for that record to be public. Sure.
We're sharing. Okay, so I have, as far as unsealing executive session minutes, we have never done that. So from the inception of the school committee to now, and I've been on 18 years, so it's never been done. So can we just broadly unseal them, or do we have to be very specific about dates?
Yeah, I don't want to, without having all the facts and circumstances, I think it's, I don't know if a blanket approach like that would be appropriate, because there may be, look, we've had lawsuits that go on for decades, right? So if those minutes were sealed because you're discussing litigation, and you did like a blanket unsealing, but that litigation is still live somehow, or it's in the appeals process, then you would be unsealing something that could still be properly sealed.
Right, but I'm talking about stuff that's 20, 30 years old. I don't think we have any litigations open.
I think that it'd be, from a broad philosophical standpoint, I think that's probably a good idea, but I just like, the lawyer would be concerned about making any kind of blanket pronouncement without actually knowing what the contents of those minutes are, and just kind of blanket unsealing them, and then all of a sudden you've unsealed something. You know, again, like I was discussing, right? An accusation of civil misconduct, right? You have employees who work sometimes. My father's in his 40th year. You know, if there was something in that record that was, again, executive session to discuss unfounded allegations of civil misconduct, and then you unseal those minutes, and those minutes are subject to an APRA, all of a sudden you get like an unfounded investigation of an allegation, and now those records are public, right? So it's really a facts and circumstances. I would not advise kind of just a blanket unsealing. I think it's what you want to do is facts and circumstances, record by record, and determine whether it's proper to unseal them, because sometimes it may be proper for it still to be sealed.
Okay, my second question is, we do a lot of building issues, and we go as a group to do walkthroughs and things like that. Does that have to be listed as an open meeting?
So we have found a violation of the OMA where a public body did a site visit because to like I think it was a solar farm, because you had the three-legged stool was there, right? You had a quorum of a public body, and they were walking and talking and discussing the solar field or whatever. So yeah, so that's an open meeting. It meets all the requirements of the OMA. I've discussed with solicitors who have had court hearings, so the public body has been subject to litigation, and the public body needed to go to the court to discuss that litigation. So you had all the elements of a public body. You had the public body, you had a quorum, and they were discussing something that's within their bailiwick. It was being conducted at the courthouse, Providence County Courthouse. So they convened it as if it was an open meeting, because now you're in compliance with both the OMA and you're at a court hearing, because that's how you comply with the OMA.
So we have 3 lengths of the stool sitting at this table.
We're discussing how to properly, abide by the OMA and the APRA. We're not discussing ourselves. Yeah.
Hi. My question is, if you have somebody who's asked, if they've asked a public body for information and they've kind of repeatedly been getting the same answer, that it would take significant time and that it's a complicated request, what recourse do they have if they're kind of getting, sort of the same issue each time?
I mean, there's a number of ways to approach that, right? If they think that the denial of the records is improper, they can seek relief through our office. If they are requesting something that has been determined to be overbroad, so the reason for the denial is that it'll take us a lot of time, then you might want to consider limiting the request to a smaller, more manageable request that then isn't too expensive and takes less time. That's the other way that you would approach it. Or figure out maybe if there's a way to obtain those records outside of the APRA process, which is sometimes an avenue available to people. That's kind of the three ways I'm thinking of it.
Okay, and then my last question is for the subcommittees. You said that those are, if they're formed by the school committee.
That's just one factor, by the way. It's
Okay.
a multi-factor test, so don't take one factor that I say is like this positive. They're definitely subject to the OMA. You consider a number of factors. But go
Okay.
ahead, I'm sorry.
Does it, so if there's a, if there's some sort of act that kind of dictates how those things are formed and whatnot, what you're saying is that those are subject to the OMA. Is that correct?
It depends. It depends on what the statute says. It depends on what the charter says. Again, in my example, it makes it a lot easier for us when it says, like, sometimes in the charter or the statute, this public body is subject to the OMA. Sometimes they'll make it that clear. Other times it'll say, like, that instrument, whatever it is, a charter or statute will say, this entity will not meet regularly, they will not have a fixed membership. And then these are all factors. You're like, okay, well, that doesn't seem to be something that would render it a public body. And then you need to take into another number of factors into account. Again, like enforcement mechanism is a big one, right? So can this entity do anything on its own? Or does everything that it do subject to approval by the big school committee, right? That's another factor to consider, but it's a multi-factor test, so it's tough to be. A lot of times I can point right to the OMA and say, yes, you have to do this, no, you have to do not, you don't have to do that, but whether you're subject to the Open Meetings Act or not is a little bit more complicated because you need to consider the entire picture, you need to have a record, and it's a little more complicated.
All right, thank you, Adam. Want to thank Adam for sharing his Saturday morning with us. We're going to take a quick break. The next session is on ethics, and that's another area that if you're new to elected office, you really have to be aware of how